Good morning, everyone, and welcome to Statewide Disability Advisory Council meeting. I'm Bobby Dutta, your SDAC co-chair. I have black hair, wear glasses, use his pronouns. I am pleased to be joined today by our fellow co-chair, Alex Pinata. Please be aware that we're recording this session for later sharing on our YouTube channel. To ensure a smooth experience for everyone, I would like to outline a couple of basic guidelines. If you're connected via multiple devices, please mute all but one to prevent audio feedback. We ask that you keep your microphone muted when not speaking. During the Q&A portions, you may raise your hand to be recognized, then unmute to ask your question. Alternatively, you can post question in the chat or send them to me privately if you prefer to remain anonymous, and I'll read them for a response from the guest. Now, let's begin our meeting. I am pleased to introduce Paula Tobler, supervising attorney in the Pathways to Work practice group at Disability Rights California. Paula's commitment to disability advocacy is deeply personal, shaped by growing up with I think Paula had a brother who was diagnosed being autistic. And despite of heavy influence by people telling to be institutionalized, Paula's parents decided not to do that. So that was a shaping moment for Paula. Paula's been a California attorney since 1990. Again, Paula's perspective was transformed in 1998 when a serious car accident left her with PTSD and traumatic brain injury, temporarily ending her legal career. This firsthand experience illuminated the vital importance of proper support for people with disabilities. Upon returning to law, Paula enriched her approach through advanced psychology degrees and work in mental health settings. She draws on both her personal and professional experiences, reality-based, informed rather than stigma-informed treatment for all people with disabilities. So without further ado, please welcome Paula Tobler.
I think I just found them.
Okay.
Thank you.
Got it. There they are. All right.
I am so sorry. Again, people, this is what happens when we don't mute our microphone. We are delaying the program. Paula, my apologies, and please begin.
No problem. Things happen. As long as we've been on Zoom meetings now, we still have problems. I sometimes just forget to unmute myself, so it's all good. So as Bobby said, my name is Paula Tobler. I'm a supervising attorney. I actually was raised with two siblings with disabilities. So I had a brother on the autism spectrum and a sister with Down syndrome. And in our family, they were loved, but their expectations for them having any kind of job or life were very low. As it turned out, that was not the reality once they were in situations where they could thrive. And seeing that made a big impression. And then having my own experience where I had gone from someone who did not identify as a person with disabilities to having very severe disabilities and being able to work my way to being not only working, but actually back to being an attorney, really made this a passion project to talk about disability and employment issues, and especially reasonable accommodations. So I'm really grateful that you invited me to be here today. So I'm going to focus today on a hot topic, the Executive Order N-22-25, which is the executive order that sent everybody back to the office 4 days a week. And if you have read the memorandum that Cal HR sent out on, March 13th, 2025 is the date on statewide guidance on case-by-case exceptions to 4 in-person days per work week. That's a mouthful. You'll see that they do acknowledge that there are exceptions to the 4 days back in the office. Now, whether they put out that memo or not, legally, there are exceptions that can be made for people with disabilities. So I'm going to talk today about how that works. So they cite the Americans with Disabilities Act. I know there's a lot going on at the federal level, and there are fears about the status of the ADA. There are also fears about, even if the ADA is there, whether the EEOC will be able to not have their hands tied as far as enforcing the ADA. So the ADA is the Americans with Disabilities Act. The EEOC is the Equal Employment Opportunity Commission, the agency that enforces the ADA, among other things. But we are in California, where there is actually a California state law, the Fair Employment and Housing Act, that also provides for reasonable accommodations for people with disabilities in the workplace. So even if you're hearing doom and gloom or worried about doom and gloom, a lot of our my funding for my job comes from federal funding. So doom and gloom is and doom scrolling is a new pastime of mine. But there's a lot to be said when it comes to labor rights to be in California. And one of them is that no matter what happens on the federal level, the state Fair Employment and Housing Act still stands. I have heard nothing, no indication to try to get rid of that, and I don't see that coming. So you still will have rights to reasonable accommodations no matter what happens. Now, I've done specific trainings on reasonable accommodations, but I'll go ahead and give the basics here again in case people have not caught those hearings videos or whatever. Although I'm sure like everybody watches them, right? Like, isn't it like 100% viewing all across the SDAC, Bobby? It's like it's #1 in the greatest hits charts, I'm sure, because everybody like gets excited about boring lawyers talking about reasonable accommodations.
It's not a boring subject at all for our audience. It's a very relevant subject. So thank you.
To start off with, you do have a right to reasonable accommodations if you have disabilities. And one of those accommodations, although I've been hearing more and more reports of employers saying work from home is not an accommodation. It is. It is a possible accommodation if it is recommended for your disability. So if you have a disability and it is necessary for you to perform your essential functions to have the work from home accommodation, like if you have been able to work from home and going back to the office, whether it's going back to the office at all, or whether it's going back to the office 4 days per week, rather than 2 days per week or whatever else you've been doing in the meantime, if that is not advisable with your disabilities and will interfere with your ability to do the essential functions of your job, then you can ask for a reasonable accommodation. In order to do that, there's a really good form on the Civil Rights Department, California Civil Rights Department website that you can fill out, so you don't have to think about what form to use or anything. I'm sure the state has its own forms too. Legally, there is no requirement that you use a specific form or any form at all.
I'm turning this down.
So you can go ahead and, tell somebody verbally. You can put it in an email. You can do whatever you want to do. But we recommend that you put it in writing. And it's really handy to use the Civil Rights Department form because it just then gives exactly what you asked for and the date you asked for it. It has all the information, and it can help clarify things if there's ever a dispute about that in the future. The other thing that's good about the Civil Rights Department form is that it has a Part B right on it for your medical verification. So In general, like the employer is allowed to ask for a medical verification that you are a person with a qualified disability and that you need the accommodations because of your disability. Technically, they're not supposed to ask if it's apparent why you need it. They're only supposed to ask if you need it. But CalHR and pretty much every HR department that I deal with in the literally thousands of cases that I have had over the years with clients that are seeking accommodations is they ask for it as a matter of course. So even if it is apparent why you need it, they'll ask for it. Work from home, I can guarantee you they're going to ask for it, and they probably will nitpick your doctor's note as well. So just be prepared for that. So you might as well use a form that has it all together, has your medical verification, and turn it all in together. It also helps because a lot of doctors are, they don't necessarily get paid to do a lot of paperwork, so they can get very kind of picky about whether they want to write a letter. And it's easier for them to write a letter if they just have to fill out the form saying, yes, I agree with the accommodations they listed above. That brings up another issue. Well, I'll handle that a little bit later. Okay. So you got your request, you got your doctor's verification. Hold on just 1 second. I don't know if you could hear it or not, but my dog decided to play with noisy things dropping on the floor. See, so I have my own like background noise issues.
We can't hear it.
Oh, well, that's good. I mean, never mind. I'll just nothing happened. Nothing to see here. That is my service dog, by the way. So at least we're supporting service dogs at work. So if you have your request and you have your medical verification, you turn that in, then the employer, the state, is supposed to enter into a timely, good faith, interactive process. Now pay attention to those three elements. Timely. One of the things that we saw in the last round when the state went to 2 days a week in the office was that these interactive processes were not being done in a timely manner. So if it's not timely, then that can be problematic. Now, there is no actual number of days that is required. Oh, 6 months, yeah. There's no okay, they have to respond within X number of days because reasonable accommodations are so fact specific. So it depends on what you're asking for, how much time is reasonable for them to figure out what they can do about it. But it does get to the point where some things are just not reasonable. It's not timely anymore. That also can go to the matter of good faith. So good faith could be a matter of whether timeliness could also be part of good faith. It can look like bad faith if, for example, there's some evidence that it's not untimely because of, serious reasons, but just because they're sitting on it, hoping you'll go away if they just don't do anything about it. One situation that came up in a class action suit was, I believe it was Sutter Health, that was just putting people on unpaid administrative leave while they worked on whether they could get an accommodation or not. But they had a bunch of people that were on unpaid leave for literally months and going into over a year. So at that point, there's a class action suit brought because people are saying this is not only not timely, this is not good faith. They are just basically parking us here without money, hoping we'll go away and they never have to deal with us, or hoping we'll just go back to work without accommodations. So be aware of both of those. And then interactive is the third element. It's an interactive process. So if they're just saying no, that's not an interactive process. If they're saying that's also not acceptable because the standard to deny is undue hardship. So if you hear a no, then you have the right to ask them, where's the undue hardship? If they can't show facts showing undue hardship, then they are supposed to grant the accommodation. even if they have undue hardship and they can't grant the accommodation, they are supposed to have an interactive process where they talk about alternatives. So, do you see, I've seen this a lot in the work from home battles. Sometimes it works out and sometimes it doesn't. So they might say, you can come back to the office, but we'll provide, when it was heavy COVID and there were a lot of people who could not be exposed to COVID, they would say, we'll give you a private office with an air purifier and you can wear a mask, et cetera, et cetera. That was their alternative to letting you work at home. The way that works is if their alternative does work, then they get their preference of the alternatives. But if that's not going to work, then you can fight that and say, no, I don't have to accept the alternative. Be aware, though, that you want your doctor's backing on that, because that would have to be a medical opinion that that is not going to, serve your accommodations. That's not what your needs require. So be talking to your doctor about whether they will back you up on that. And you're going to have to go back and forth. The other thing to know is that if they say, well, we can do this, and so you have to go back to work tomorrow, you do have the opportunity to say, again, it's supposed to be good faith and interactive, not just we tell you, we take 6 months to decide and then tell you you've got a day to decide on your end. You can say, and it's a good practice to say, I need to discuss that with my doctor. I'll go discuss it with my doctor and see if that meets my medical needs, and then I'll get back to you as soon as I can. So be aware that you can do that. The other things that come up a lot with this is, finding all kinds of creative ways to deny it. So saying, for example, that it's an essential function of your job to be at the office because, you can't possibly collaborate outside the office. They say that because there is a line of law that was basically pre-pandemic where the courts were very deferential. And I think the courts still will be deferential to the employer about what is required of your job. However, if you have been working from home and able to collaborate and be productive and do everything that your job requires of you, it's much harder for them to say now that it is somehow essential for you to be in the office. On the other hand, if they have been waiving some requirements or had been waiving requirements while you were working from home during the pandemic because they had to. So for example, we had even our receptionists working from home during the pandemic. When the pandemic was over, not over, but what do they call it now? And they pretending it that COVID's not a problem anymore, but you know what I mean. When people were returning to work, then you could say that a receptionist, even though they'd been able to do their job from home during the pandemic, they still had to go back at least some days in the office because now, once again, clients were showing up at the office and we needed to be at the office. Somebody had to be there to open it up and greet clients. So it really depends on the job. But in general, most people that have been working from home by this time have shown that whatever is essential to their job functioning, they have been able to do at home. So if there's giving arguments about this is essential to your function, you can fight on that ground. Another roadblock that I'm seeing a lot though is, and it's getting worse over time instead of better. I'm going to use Kaiser as an example because they're the worst that I see. I can't even think of a doctor that was not Kaiser that's saying this. But we're hearing that that medical providers are saying they cannot provide the medical documentation letter because Kaiser has a policy that they are not to do so. That has been an ongoing problem, but I'm hearing lately from several sources that they are being told specifically you cannot do work from home as an accommodation in a Kaiser letter. I can't say that I actually have firsthand knowledge of what's going on to the larger extent, but I do know that when I had Kaiser, it was very difficult to get a doctor's letter for my own accommodations, and I had to do a very creative workaround. I think, this is my opinion, you can take it or leave it. I think the bottom line is money. Kaiser or
course
any
it is.
insurance company makes more money by catering to the employers that will make, put them on their plan for all their employees, put them on their benefits plan and pay a chunk of the premium. So they are more concerned about, for example, staying in California, the state of California's good graces, so that they have access to all those state of California employees using their plan, than they do the individual employees, which is, I think, highly problematic when you're a medical provider, because those employers may be a customer of Kaiser as an insurance company in some sense, but the relationship between the doctor or therapist or whoever it is and the patient is the relationship. If they don't have a relationship or a duty of care to the employer. I have problems with this, but the reality is that it's not necessarily seen as a problem by people that can do something about that legally, because if you talk to legislators, in fact, Bobby and I were both on a assembly select committee on this, on barriers to employment with people with disabilities. And in fact, if you want to see, that's recorded online, and I'll also give you the exact name and the person who's the head of that, so that you can use that as a resource if you're having this problem. But basically, if you're looking at the legislature and they're saying, well, we passed the Fair Employment and Housing Act, so you can we have this whole process, and we have the Civil Rights Department, we have the EOC for the ADA, we have all these means for you to get your accommodations. So we are worrying about other matters that we need to pass legislation on. They don't recognize it's a problem unless they've tried to get a letter out of Kaiser for their accommodations, and even then they might think it's just their doctor. So part of the problem is the perception that because laws have been passed, that this is not a problem area. However, HR departments, not just Cal HR, but many HR departments are getting very creative in ways to throw up barriers within that system that are problematic. So that if you, I would say, I have to be careful what I say, because I don't do any lobbying under my funding, but I will say that in my personal case, I left Kaiser and went to another option specifically because of the difficulty in getting a letter for reasonable accommodations, and because of how horrible they were with mental health therapy, and I have mental health disabilities. But that whole issue was big for me. So when you are at open enrollment, if you are someone who has disabilities and needs accommodations, you have the right to put whatever you want into the mix of who you decide to choose as your provider. I saw a comment that this is spreading to others as well. Like I said, I am just telling you where Bobby and I were on that panel. And there's a recording online about that panel, if you want to hear what everybody on the panel, several panels, said about various issues. Is the Assembly Select Committee, the California Assembly Select Committee on Opportunities and Barriers for People with Disabilities in the Workplace. And that the head of that committee is Liz Ortega, an assembly member. So that is a resource that you also can have if you're having issues that you feel, should be redressed in that way. I'm going to leave some time for question and answer. I keep seeing like little questions and comments popping up, so I will get to those at the end. And I'm almost done with my comments anyway. So let's say you don't get your accommodations. So they can say, we're not going to give you your accommodations because you don't have a doctor letter. You can problem solve other ways to get a doctor letter, as well as kind of talking about the universal things we've been talking about trying to get out of that system altogether. That can be fact specific, but what I did is my Kaiser psychiatrist would not write a letter without releasing all of my medical records. She would release my medical records, but wouldn't do a letter. And I'm sure you can all imagine how that hit me as a human being, never mind an attorney, to think that my employer would have access to all of my mental health records, just because I need a no cost, very, non-problematic in my mind anyway, accommodation. So what I had her do was write a letter to me. So I wrote my accommodations and I said, hey, would you agree that these would be helpful for me given my medical issues? And she was willing to write a letter that she agreed with them addressed to me, because I said, you can write a letter addressed to me with anything you want, right? And then it's up to me. Whoever I show it to is my problem and not yours. That got her out from under one of the problems she was understanding was a problem that Kaiser had with the letters. And I was able to submit it. Other people are getting other providers to do it, or going back to previous providers. People are brainstorming a lot of different ways. And in fact, I was talking to Bobby as this was, as we were kind of waiting for everybody to come. I'm actually thinking about starting a YouTube channel to just have discussions about these kinds of things so we can all problem solve together, because I think a lot of times they divide and conquer. We have disability groups by disability, but it's hard to find like, where do we all problem solve disability employment issues, right? And give each other feedback. Also, I think it would be helpful for managers who want to do the right thing but don't know how to have some help. Maybe I'm naive, but I think if managers had more help with their management skills, it would go better too. But yeah, so let me know if you're interested in that. And if I ever end up doing that, I have a daughter who's in social media. She's a digital media, like digital marketing person. So I should like bug her about it. But yeah, let me know if you'd be interested, and I'll let you know if I end up doing it. And you can find me on LinkedIn. You can find me at Disability Rights California. All right. So if you're having problems with the doctors, you can also, one of the arguments I made was, if you choose who my insurance providers are, then isn't that problematic if you're choosing providers that interfere with my ability to get accommodations? It gets so ridiculous that I actually had a Kaiser employee that used Kaiser for their insurance too. So they were going to a doctor in their same Kaiser facility, and they also had accommodations, these same accommodations through Kaiser when they worked at a different facility. When they moved facilities, HR was denying their accommodations because they didn't like the doctor's letter. And I was looking at them like, okay, but you're also the HR over that doctor. It's a Kaiser doctor. Why didn't you go tell that doctor and give them training on whatever you want in the letter? And they were just using it to stonewall. So if that comes to that, you may end up filing your Civil Rights Department complaint or EEOC complaint or EEO complaint at that point. So we'll get, that kind of takes us to our remedies. If you're not getting the accommodations, or they're like the delays are too long, you think it's, they're not acting in good faith, it's not timely, they deny you for reasons that you don't believe are undue hardship, or they don't give you a reason, you can take it to the entities that are in charge of enforcement. And in fact, you have to, because even if you want to file a civil lawsuit, with these matters, you have to exhaust your administrative remedies first. That's just a fancy way of going to the administrative agency and letting them have the first shot to take it on. Those administrative agencies are the EEOC for federal and the California Civil Rights Department for a state. It's people always ask me which one is better to file under, and that really depends. They both tend to be backed up. Sometimes one is backed up more than the other. And right now, I just was on a panel with an EEOC attorney, and I've also worked on some other things with the EEOC attorneys. Right now, they're in flux. So they have hiring freezes. They have the like emails that went around telling people to retire, stuff like that. So they're understaffed, and they were somewhat understaffed before anyway. And then there also have been directives that have come down saying like, there was one that they told the the new, I don't know if they're official or interim head of the EEOC under the new administration, told them to drop all cases they had that had to do with, for example, gender identity discrimination. They don't know what's going to happen with even that kind of stuff, where they're going to say what they can or cannot do as far as their fund and also their funding to do anything at all. So right now, a lot of people are choosing the California Civil Rights Department. When it comes to state employees, sometimes they're wary of the California Civil Rights Department because it is a state agency. They're supposed to act independently. Some people don't trust that, so they prefer to go to the EEOC. So basically, that's your choice, which direction you want to go. They cross-file, so if you file with one, they automatically cross-file with the other. So all state and federal claims are taken care of. The other difference is if you get a right to sue letter, which is the most common result from these filings, you'll get a little bit more time to file through the CRD. So anyway, you can file with the EEOC or the CRD, and then since you're in the state system, you can also go through your EEO process. I'm not going to comment on that. I also know a lot of people are wary about that process because they feel it is even more influenced by like CalHR, and they don't feel like they get justice in that system. I don't end up talking to a lot of people about that system, so I don't know if that's just some people who feel that way, but actually it works well, or if it's not working well. So that is another option that you can choose, and that is a whole different system with tight deadlines, so make sure that you understand that. So those are your options to fight a bad decision. I do know of one state employee that went through this California Civil Rights Department, and the CRD did do a full investigation, or at least an investigation, and they found that there was some merit to the claims. They still provided a right to sue, so she had to go get a private attorney rather than taking it on as a lawsuit on their own because of their resource issues. They have to pick and choose what battles they fight themselves. So I'll just tell you that the more you can let them know wherever you're filing, we've heard the same thing from the EEOC, like because the state is kind of convoluted, there are different departments, they're all under CalHR, but they also have their separate HR departments. There's a lot going on. It can be hard for them to track how much of a problem this is within, like, for example, the state of California, because they have a case from this department here and a case from that department there, and it seems like it's just one person's problem. And when they're all across the state, they're going to different offices and they're going to different investigators. So to the extent that if you know and can coordinate with each other and are willing to like be witnesses for each other, or at least be able to be named in each other's complaints as people that already have that also have the same problems, so they can connect your claims together. Like they get complaints filed from John Doe, Jane Smith, you know, whoever else, but they see that it's all the same problem with the same issues, then the more likely they would be to take that on as a EEOC lawsuit or a Civil Rights Department lawsuit, rather than give you a right to sue and you go find your private attorney. But the most common action that happens is they give you a right to sue, and then you have to go find a private attorney to file a lawsuit in civil court. Or you can file one yourself. I just wouldn't recommend it because it's a lot more difficult than it seems, but that's a possibility. Okay. So let's go to questions. We got a new version of Zoom, like Zoom Workplace. I have to figure out where the
So we have Glenn with his hand raised. Glenn, go ahead, ask the question. Then I'm going to read the questions that posted on chat. But go right ahead, Glenn. I think you're muted, though.
Hi, good morning, Paula. I have a couple of questions from what you brought up here. I think it is very difficult to navigate this, and I think the first roadblock here, like some of our folks are indicated. So that's my question number one: is the provider themselves, that sometimes they're not really, or most of the time they're not really, how do you say this, receptive to neurodivergence, so that. And it is very difficult to find a provider that is receptive to neurodivergence. Like, for example, I was able to get one that says, I asked to look for around, this is sort of an insurance, has some kind of a advocate, like a customer service advocate group. And they tried to find out, and I asked them, he says, can you find like a neurodivergent friendly specialist for this specialty? And then they went around and looked for it, and I hope it's gonna result into something. And then they said this. Then they came back. They gave me a list, and then I called, made an appointment with this specialist basically, and then I had to clarify it too with the office staff over there. And the office staff said it's the provider. Only one provider there in the office is neurodivergent sensitive. So I don't even know how it's gonna result into, because I think backtracking this particular condition that I'm talking about, when I bring it up to the couple of specialists I've seen, they always gonna say, "Oh yeah, next time we'll take a look at it. Next time I'll take a look," until the second time I got into. That's why I went into this motion of getting this particular one next week. So then. So I still don't know what is gonna happen here, with this appointment. And like you pointed out, it's very difficult for them to get to write a letter or something like that. So that's number one question. I think finding the provider is, how do you find a provider, right, that's receptive to neurodivergence? It seems to be very, very difficult. That's number one. And then number two, as my question number two, as far as Disability Rights California, what services are you able to provide to folks like us in terms of, hopefully, of representation or advice or things of that matter? So thank
Glenn,
you.
I'm just going to interject. You can go onto the website and study all the things that they have to offer, because there's a lot of questions. Do you have any other questions specific for Paula?
Oh
I
yes,
will-
I did look at this Disability Rights California before, but
Okay.
I couldn't understand it because I have neurodivergent kids who
So-
need representation for special education, but I didn't get
Mhm.
anything, and I even
So
emailed
you can
somebody there
also-
too.
We have a one intake line. So if you call the intake line and say what your problem is, they can tell you whether they handle it or sometimes they can give referral resources. They can't, or they can put you with the right unit. So I would just call the intake line if you're not sure.
Oh,
As far as
okay.
the finding people who understand neurodivergence, it's actually difficult for a lot of people who are diagnosed young, and especially if they went through the special ed program. So they've just not like you don't go to see a doctor, regularly for neurodivergence, for example. So that can be difficult, but
Dyslexia is considered neurodivergent, correct?
yes, dyslexia is
But you don't
considered
need to see a doctor
neurodivergence.
continuously. Like once you've been diagnosed, you've been diagnosed.
ADD, ADHD. Like I was diagnosed with ADD when I had a traumatic brain injury, but that was in like 1998. So when I've needed it again, I've had to go through testing again to prove that I have it. So there can be different problem solving, but you can also contact me outside of here for your specific issues and we can problem solve how to do that. I actually am in a lot of spaces now doing panels on neurodiversity in the workplace. And I'm actually working with some of the state council people, business advisory councils and others to try to make this easier and to help people understand you don't even really need a doctor's appointment. If you're seeing these issues, then you don't need a doctor to tell you they're an issue. And if the fix is really easy, just do it. So contact me if you're having those issues.
Thank you, Glenn. Great question.
Thank you so much.
I'm going to go to the next person. I think L2654. Please unmute. Ask your question.
Hi there. My name is Michelle Haunold Lorenz. I'm an employee over at Franchise Tax Board. I am also a steward for our union, and I assist coworkers in getting reasonable accommodations. Something that's come up recently, and it impacts me because I'm recently diagnosed disabled. I'm using dictation software, and I have a number of coworkers also using this software. Franchise Tax Board is a production-based entity, and we are running into roadblocks getting reasonable accommodations as far as the production levels. We're required to be within a certain percentage rate, and because of the dictation software, it functions much slower. It doesn't always interact with our programs, so it slows our level of production down. Do you have any recommendations? I was told there is no RA for production, but it just seems unreasonable that that's not something we can address. Do you have any comments on that?
Yes. If you look at the EEOC guidance on reasonable accommodations and undue hardship, which is a great resource, it even points out that employers do not have to lower productivity standards, either quality or quantity, as a reasonable accommodation. However, if you call me, I work on this a lot because a lot of people kind of need that, but sometimes we can figure out other ways to get what you need so that you can meet productivity standards with other accommodations that are not already labeled as unreasonable by prior EEOC or CRD decisions.
Thank you.
I'll put the EEOC guidance in the chat.
One other question that just posted in the chat that's important, it's relevant. Mimi clarified that the right to sue that you mentioned, that EEOC, there is a 90-day statute of limitations, meaning you've got 90 days to file that suit. And the other distinction that she also pointed out, CRD, California Civil Rights Department, has right to sue 1-year statute. Meaning if you file a complaint, they give you a right to sue letter, you got 1 year. But anyway.
Yeah, thank you for that. I think I was kind of rambling, but yeah, it's longer. It's a year for right to sue for CRD, and it is 90 days for EEOC. And it's also different, your statute of limitations. Okay, so the statute of limitations where you have to actually file with the EEOC or the CRD. CRD is usually 2 years. EEOC is like 360 days. And then once they give you a right to sue for CRD, it's a year, and from EEOC, it's 90 days. So it's coming and going. You get longer time frames through the Civil Rights Department.
Great. The question that came here, somebody asked, can the employer tell you to take time off while they're reviewing their issues involving reasonable accommodation requests? Meaning, can they ask you to use leave, take time off because we just don't have the resolution yet? We are backlogged. Many departments are with this request, particularly with the 4-day mandate now. They're getting a lot of these requests. So what's your recommendation?
Well, yeah, that's one thing that goes to whether it's good faith or not. I mean, okay, so especially in this case where they decided to do this, and if they decided to do this when they didn't have enough HR personnel to handle the request, that's problematic in my mind. So, you should be thinking of these things and bringing them forward as complete. So if they're telling you that, if they end up telling you that, then you can go ahead and file like with the CRD and say this is already a violation because they're taking so long. This is not a good faith interactive process. And I think it's important to do some things like that because like like they found with Sutter, like if they're doing things forever, then that's problematic. Now, the other thing you can do is get pressure on them to let you have the accommodations temporarily while they go through the process, because that's an option to them. So if they're saying, we can't possibly get to you for the next 6 months, 8 months, a year, or whatever, because we have so many requests and so few HR people, then the argument should be fine. Then let me have it temporarily while you decide, rather than have me not working at all or causing problems with my disability. The other reason that that's problematic is that if you keep working without your accommodations for the months and months while they are deciding, then in the end, they can use that against you because they say, well, look, we've decided you don't need it because you've been working all this time without it. You've been going into the office 4 days a week. So obviously you don't need it in order to provide your essential functions. So those are all things to think about, whether you decide to wait until you get a decision to contact one of the administrative authorities, or whether you just contact right away to report an issue or go through your EEO process. But a lot of it also is that they're putting, and it's a common tactic on others, but they put their administrative problems on the person with disabilities, which is inappropriate. So they find a lot of creative ways to do that. But that means that it's necessary to find creative ways to push back on that.
The other question that posted here by Rihanna says, my concern is how Zoom virtual work has become, and the stat has been so slow to update offices with needed technologies and quiet spaces. Now, the quiet spaces is quite relevant given the fact that now more people are asked to return to work and they have limited space and the physical footprint that makes it hard to accommodate a 4-day work in-person schedule. So a lot of departments have to kind of juggle that in cooperation with DGS, who is handling the space allocation for many of the state departments. So again, she's just commenting on something that she observed.
Yeah, and that's actually a common accommodation for all kinds of disabilities, is to have quieter spaces and fewer distractions. So at the minimum, they should be offering you noise canceling headphones, cubicle that's away from other people, something to help you. So if they're not doing anything at all, file right away and say they're not even trying. If they're trying to give you other options, you could see if those might work. But yeah, that is problematic.
Another person says, well, curious, what plan do you found to be better than Kaiser? Are you open to share what you moved to? And you don't need to answer that.
We only have one other option because we're smaller. So I went with the only option that was not Kaiser, and have had, it's been better than Kaiser, but I have my own issues with it, but it's better than Kaiser. So I have been able, but that also, I will tell you that I did find out that the other option has psychiatrists on their plan that I have used in the past. So I connected up with a psychiatrist that I hadn't seen in probably over a decade, but they did remember me and it was a lot easier. So that might be another thing to see if you're looking at different plans, like do you have other providers from the past? What are their facilities near you? Talk to each other about what your experiences are with whatever plans are available to you.
Someone else commented, I have United Healthcare with Kaiser and have blindness and mental. My plan is not expensive and I have good care, health. So evidently she's got a positive experience with her plan. So are there any other questions? We have Alex. You have your hand up. Go ahead, Alex.
Thanks, Bobby, and thanks, Paula. First 2 comments and then a question. So about your scenario of releasing medical records and the workaround that you figured out to get what you needed. I've had my own experiences with reasonable accommodation, and I think that's a good scenario and advice as a reminder that if you're told no by anybody in the process, to consider, instead of just walking away, to ask alternative methods of obtaining what reasonable accommodation you're needing or what documents you're needing filled out in a certain way. So that's just a comment. And then another comment is about reasonable accommodation and neurodivergence, which I'm hearing some comments about. I personally think that there's an increase in people requesting reasonable accommodations to work from home, for example, because I've been seeing that there is from my conversations with people, is that it seems like there's more people that have realized that they are neurodivergent, being given the opportunity to not work in an office environment, in a state office, and so they're working from home, and now it's a whole different environment, and they're working better or more effectively or more efficiently given that circumstance. So that's my two comments. And then a question is that about reasonable accommodation process. So you were mentioning essential functions, and about if you've already been doing it, that there could be issues. But what if there have been changes to your duty statements after submitting your request for reasonable accommodation, which could be in response to your request for reasonable accommodation?
Good question. That depends on whether it's good faith, and that depends on whether they're doing it to try to get out of an accommodation or what they're doing that for. So in that case, you might end up needing to get an attorney who can do discovery and get all the documentation about that. But I would push back on that, because that's not appropriate for them to at least not explain to you, why are you changing the duty statement? Did you change it for everybody or just me? Is it for every, like, especially within the state, like you have duty statements that are very broad. Look into, ask about the background and be prepared to talk to an attorney about it. Another thing that I meant to mention but didn't is, if you never, like when you're talking about people that just realized when they were working from home that they might be neurodivergent or work better with at home, you are not precluded from asking for an accommodation just because you didn't ask for it before. So even if you never asked for one before, and now you realize that you need it, you can still ask for it now, and they can't push back. Well, you didn't ask for it before, you're just only asking now. This, before the pandemic, you worked in the office. That's not their business, but you can still ask. And also, if you already have an accommodation from the last round and you have work from home, they are not supposed to take that away from you without an interactive process and a showing of what is the new undue hardship that supports that change. So if they're saying, oh no, all bets are off, now you have to start all over again, that's not appropriate. You should be appealing that decision.
Okay, thank you. And then just a side question about reasonable accommodations. So do you have any examples of unreasonable responses to reasonable accommodation requests, aside from just a flat out denial?
Yeah, no is a common one. It's outside our policy. That's not appropriate. Doesn't matter the policy, they're outside of policy. Now everybody else will ask for it. How do I explain this to everybody else? That's not appropriate. What are some others? You were just fine before. That's not appropriate, because disabilities can change, jobs could change. If I think of others, I'll tell you, but maybe I do need a YouTube channel just so that I can like keep thinking and adding to my comments.
I definitely encourage you to set one up. And then just
I hate being on camera, if you can imagine. I love doing presentations like this, but I get really nervous. I don't know if you can see it. Well, you could probably see it because I keep like fumbling my deadlines and stuff, but
No, you're doing great. You're doing great. Wonderful.
fantastic. And I empathize because I also have a TBI from back in 2017 from a vehicle accident. So it's more mental gymnastics for me since that time. And then I saw, just jumping off of my own questions, I saw that in the chat that there was a question. Scrolling down to it, I just saw it pop up. Oh, what are examples of undue hardship for denying of RTO?
so they could say it's like expense is usually the undue hardship, but RTO usually isn't expensive. It used to be a big one for RTO or for work from home, because if you had to give them all the equipment at home, that was expensive, but they've already invested in that expense when they sent you home during the pandemic. So that kind of eliminated that one. Sometimes they could say security reasons, like they were able to kind of be lax on security stuff if you're in a high security field. But then once you don't need it for the pandemic, then they want you back where they can secure everything more. We have a lot of sensitive information, and we just have trainings on and really strict discipline if you don't follow them as far as keeping things secure. But that could be a legitimate reason. It can be if it interferes with the operations. If you look in the EEOC guidance, and I put the name of it in there, you just Google that and look through it. It has a whole section on undue hardship, so it explains a lot of it. But yeah, it's actually pretty hard to prove undue hardship. I did a panel for the LA County Bar Association Labor and Employment Law division at their big symposium this year. And there's an EEOC attorney with me there, and we were saying like how difficult it is to prove undue hardship when it's all said and done. But a lot of times they do this because people don't fight back, or it takes so much to go through the process of fighting back that they kind of, just deny it and hope a certain percentage of people will just make do. So it makes it easier for them.
Thank you. Then I have another question. It's not for me though. It's from somebody in the chat.
Okay.
And this is from Nina. So it says, as a Caltrans employee with a medically documented disability that requires remote work, I've been denied a reasonable accommodation for full-time telework, even after proving I've successfully performed all job duties remotely since August of 2023. How can disabled state workers challenge denials like this when the refusal seems to be based on outdated notions of essential functions rather than actual performance or operational needs?
Yeah, that doesn't sound like undue hardship to me. And it doesn't sound like it's really an essential function. It's fact specific, but take it to the EEOC or the Civil Rights Department and let them decide. And again, if you know of other people, coordinate amongst yourselves, because if you know other people that are being told the same thing and getting these denials, make sure you clue them into the fact that it's not just you, and hear the names of other people so they can go through their database, collect that all, and see that it is a big enough problem for them to take on rather than just making it a personal problem.
Thank you.
We have somebody else with their hand up. Jeanette, go ahead, unmute and ask your question.
Hello, I just wanted to mention that I have Western Health Advantage with the state of California. And I just wanted to say, if you're a state worker, that might be a great option to consider. They have Optum for mental health care. And Optum has been truly amazing. They permitted me to meet with my therapist extra days a week temporarily due to some severe mental health challenges. And it's been life-changing for me. I got out of an abusive relationship, and I'm safe now. And I don't believe that I would have done that without that extra support from my therapist because of some traits that I have and stuff. So I just wanted to share Western Health Advantage, Optum mental health care. If you're a state worker, I highly recommend, and I know there's other good ones there too. So thank you so much, everyone.
Thank you. Thanks for that. This is why we like this platform. This is a resource sharing for everyone. And what you just presented is going to help a lot of people who are on this call.
I'm seeing some other questions about the process.
Yeah.
My time is running low. So
right. So one of the questions that came up is, what about when you have both EEOC and CRD right to sue letter? Can you file both, like you got right to sue from both entities?
And that doesn't really matter as far as you sign both. Like, a right to sue letter just means you have the right to go file a lawsuit in civil court. So you would be suing your employer. Like, it doesn't really matter. But if you go to an attorney, they're going to want the right to sue to attach to their complaint, because the judge will say, did you exhaust your administrative remedies first? The problem I see with that is whether it would be the shorter deadline from the EEOC or the longer from the CRD. And I'm not sure, because I haven't had that. So talk to an attorney, start talking to labor law attorneys right away so that you don't blow your deadline.
So there are other questions here. One of the questions, this is going to be the last question I'm going to pose. Which departments are claiming they have backlog with RA request? And if anybody wants to speak to that, unmute or put it on chat. Otherwise, the rest of the questions, there are follow-up questions, Paula. We don't have time for you to respond to all of them now. Would it be okay if I presented those to you and I will share your response whenever it's convenient?
Absolutely. And I'm willing to come back anytime, or you know where to find me. Actually, it would be good to connect if you can through LinkedIn, because like I said, I don't know what's happening to my funding day in and day out, but I can always respond through there. All right.
Great.
Thank you.
Thank you. Thank you. Again, Paula, this was very helpful, educational, and I thank you so much for showing up here and doing this. Please come back and do this again. We always enjoy having you here. And again, you're welcome to stay on.
My pleasure. Thank you.
Thanks.